Hello everybody, so I'm George from Ireland. Welcome back to my English law channel. Seeing me from a different angle, in a different location now. I'm an international man of mystery. So today I'm going to be talking about a new and obviously highly exciting and delighting topic in law. We're looking at settlements, strict settlements, trusts for sale, but now there are trusts of land. So we looked a lot at co-ownership, and this is a very tricky topic. So it's hard to know when two or more people gain their rights in land. So the land register will say who the legal owner is, proprietor we often say, but it doesn't say who also might have equitable rights in the land. So there's a law on settlements and the law on trusts, as we usually say today. We normally don't use the word settlement anymore. And this law on settlements governs how land law recognise the rights of people who are not down in the register as the proprietor of the said property. So these rights can be through express trusts, as in those which are intentionally created by the settlor, S-E-T-T-L-O-R, not E-R. The settlor of the trust creates it in consonance with the statutory requirements, certain formalities that must be fulfilled. Or a trust could be created impliedly. A court may interpret a certain course of conduct as giving rise to an implied trust. Trust can be created by law through a constructive trust. There's also a resulting trust. Proprietary estoppel can lead to a trust. We'll come on to proprietary estoppel in greater depth in another video. Someone relies on something, relies to his detriment, it was intended to be relied upon. There's a question of unconscionability. It would be unconscionable to allow someone to renege on his promise and get away with it. So there's also co-ownership. There's joint tenancy and tenancy in common, and we'll come on to those in another video about people who cohabit in a house. But now I'm going to think about how laws have been used to control trusts of land. So remember, there's the Trust of Land and Appointment of Trustees Act, TLATA is my acronym for it. So section 1 thereof is passed in 1996. It creates trust of land, and it says it's any property which consists of or includes land. Remember, even if you're a 10th story flat, that's still land. It's connected to the land, though indirectly. And this is whether express, implied, resulting, constructive, and whether created before or after the act itself came into force, except for existing strict settlements, where strict settlements take effect by way of the trust of land, because everything after 1996 is like that. Anything created after 1996 is not a strict settlement. The legal estate is vested in the trustees of that property. So a trust for sale of land were then made into trusts of land. So trustees of land now have greater latitude than they used to when they're trusts of sale under sections 28 and 29 of the Law of Property Act 1925. TLATA is very relevant here. It's given them the legal authority to delegate their powers to any beneficiary over 18 or anyone beneficially entitled in possession. So this is how it differs from the pre-1997 regime, because the 1996 Act only took effect in 1997. So they don't have a duty to sell the land anymore, as per sections 4 and 5 of TLATA. There's a doctrine of conversion. This means the interest of the beneficiary in the trust of sale is regarded as an interest in personal property. So that doctrine of conversion was done away with, as per section 3 of TLATA. So the overreaching machinery, meaning when on payment of the purchase money to two trustees or to the trust corporation, the interests of the beneficiaries are held to be overreached, that doctrine remains good law. So beneficiaries usually have the right to occupy the trust land as per sections 12 and 13 of TLATA. Remember, previously there was no such assumption. So the rules relating to consent and consulting with between trustees and beneficiaries, those are almost the same as in trusts for sale, which you found in the Law of Property Act 1925, section 26. But sections 14 and 15 of TLATA take it a step further. They allow a trustee or beneficiary to apply to a court for an order about the exercise of the trustee's functions, and in the law on these matters, the court can think about it and decide whether they're going to grant the application or not. But you have to note that you can only fully comprehend TLATA, unsettlements and ownership of land, if you look at both together. But anyway, so more about TLATA. So TLATA was a major reform, because up until then there had been the trust for sale, and the presumption here was that any co-owned land held on trust was intended to be sold. So this was almost inexplicable, bearing about with the fact that the land can be used as a home, and mostly as houses, flats, as residential properties. These are not commercial properties or even farms in the majority of cases. So the trustees are supposed to sell it. They feel it's a dereliction of duty not to. So TLATA changed the old trust of sale into the new thing called trust of land. So trust of land provisions, they explicate how the beneficiaries of the trust of land could occupy the trust property as a home, and there was no assumption that it was supposed to be sold, though often that there's a possibility that you can sell it, and sometimes that happens. So this is crucial. TLATA in sections 14 and 15, it adumbrate the issues that the courts must consider when they are judging whether or not a property should be sold, whether it should be kept as a house for people to live in. The courts need to bear this in mind, especially if there's insolvency, if there are creditors in a mortgage, there are children who need housing. So the case law often favoured the creditors over others, unless there were extraordinarily extenuating circumstances. Anyway, thereafter, the provisions about the sale of the home that comprise the trust property are vital when we consider what the law is really about here. So you have to analyse the situation, and the courts will also analyse it when they're deciding whether the trust property has got to be sold. So there are many arguments about whether property under the trust of land should be sold or should be kept. So TLATA took a new view of the situation, which trustees in a trust for sale could postpone the sale indefinitely. Usually a sale was ordered because they had to pay off some debts, but creditors in an insolvency or mortgage situation would demand the sale. So no other sort of person would have been in such a safe position as they are now in TLATA. It was very hard for people who occupied the house to stop the trustees who wanted to sell the property, particularly when their creditors hammering on the door, because the courts would almost invariably say property's got to be sold. So how about TLATA about any disagreement as to a sale? So when there is a dispute between the beneficiaries of the trust and the trustees, if some or indeed every beneficiary wants this to happen, then it's open to the parties. They can petition the court, and the court will decide what's going to happen next. The parties could seek a court order pursuant to section 14 of TLATA. The court can, under the same section, make any order that it deems just. This is what section 14.1 says. Any person who is a trustee of land or has an interest in property subject to trust of land may make an application to the court for an order under this section. So what is the remit of this court? Anyway, section 14.2 goes on. The court may make such an order. A, relating to the exercise by the trustees of their functions, including an order relieving them of any obligation to obtain consent or to consult any person in connection with the exercise of their functions, or B, declaring the nature and extent of a person's interest in property subject to trust as the courts think fit. So it goes on. The main issue here is whether these matters the court takes into account, what matters the court takes into account when they are exercising their authority pursuant to section 14. So section 15 says there are 4 factors they must take into account. A, the intention of the persons, if any, who created the trust. B, the purposes for which the property subject to the trust is held. C, the welfare of any minor who occupies or might be reasonably expected to occupy any land subject to the trust as his home. And D, the interest of any secured creditor or beneficiary. So those are the 4 factors. So remember, in the previous section, it said that the court could say the trustees no longer have to consult the beneficiaries. Any person, that would include a beneficiary. So a court has to first of all think about what the settler wanted when creating the settlement or the trust. And second of all, what is the purpose of the trust? Is it to provide for the family or what? Provide for a charity or what? So provide for the family financially or provide a house, even though there's no cash. So the trust is created for an express purpose. If the purpose is to provide a home for people to live in, well, then obviously that's the priority. But if a trust is created for investment, then generating income is more important, and the house is going to be sold. Okay, third of all, there was welfare. So the wheel of children who live there. So mine has got to be under 18. So children almost never give any money towards buying a property, and children can't own property on their own, and they can't secure a loan or anything like that. So case law has usually not looked into their interests. And they're thinking, well, they're just going to go wherever their mum and dad goes. So this provision gives the position of children a legal standing for the first ever time. Lastly, the interest of a secured creditor might be a mortgagee, a bank, for instance, lending money, or someone who's owed money through business. So these people could have rights granted to them over the property if they're secured creditors. So Res Citro 1991 is a crucial case on this. So the position is that the interests of insolvent creditors override those of other people. So in Res Citro, it was said that it is no bar to an application for sale on behalf of the bankrupt creditors, that the loss of the house was bad because the trust was all about the house, and it would oblige the family to leave the area, and the children would have to go to a new school. Tough, the court found for the claimant in this one. So anyway, the sale of a property could not be prevented unless the situation was really egregiously bad. So this is what Lord Justice Nurse said in Res Citro. What then are exceptional circumstances? As the cases show, it's not uncommon for a wife and young children to be faced with eviction in circumstances where the realisation of a beneficial interest will not produce enough to buy a comparable house in the same neighbourhood or indeed anywhere else. And if she has to move elsewhere, there may be problems over schooling and so forth. Such circumstances, while engendering natural sympathy in all who hear of them, cannot be described as exceptional. They are the melancholy consequences of debt and improvidence with which every civilised society has been familiar. Close quotation. So if they have to move out, tough. All right? That is the nature of things, and the court's not going to intervene. They're going to lose their home. Okay, there are other situations. Sometimes there's an application to sell a house, and that application is turned down. Ray Holiday, 1981, was such a case. In this case, someone was bankrupt, and he got into bankruptcy. He petitioned to do this, then he could shut up the creditors, and the debt he thought was quite small in relation to the value of the house. So he thought it wouldn't be any real problem for the creditors to have to wait for the bankrupt person's children to grow up, and they could sell the house after that. Anyway, a hardship is caused to children or the family as a whole by selling in favour of the trustee in bankruptcy. So that's just not part of the ordinary hardships of life, so courts usually won't intervene. So you can see there are various interests to be balanced here. The court has got 4 factors to consider, as adumbrated herein before. These are not sort of order of priority. I don't think that they're set out A, B, C, D. They might be all of equal importance. Okay, so what are the reasons for TLATA? That was to put people on an equal footing, different groups of people who are not creditors, but who need their requirements to be taken into account when we're possibly selling a home. So what's vital here is the legislation doesn't say which of these different types of people should prevail. So the statute only says the court must consider the position of all these categories of people. In the old case law, still matters when we're deciding how this is going to be applicable from now on. So prior to 1996, the law usually saw the house as simply an asset and could be sold to turn a profit. The sale of homes held on trust was only to be postponed in the most extraordinary situation. But the law after 1996 considers the home to be not simply an asset, but really that, a home. It is a place for people to live. And so that's the priority, that it's a domicile, not that it's something which has got financial value. So there are situations which were held to be so extraordinary that delaying the sale was allowed by the court. The debt was so tiny and was only a fraction of the value of the whole house. That was a Ray Holiday, 1981. How about when the bankrupt person's spouse was dying and had particular needs because of the medical situation? That was in Clawton against Charalambous, 1999. Or where the property had been changed as to make it suitable for the occupant who had particular housing needs, problems with mobility, Ray Gorman, 1990, and they couldn't easily find another house that would accommodate this person's particular disability. There was another situation where the bankrupt's wife had already been diagnosed as a paranoid schizophrenic. That was in Nichols and Land, 2006. So dragging that person out of the house to a new person was judged liable to aggravate the psychiatric situation appreciably. So apart from these very narrow situations, the court usually orders the property to be sold because there's an insolvency situation. The secured creditors and the mortgagees, they need their money. It'd be unfair to them, and otherwise nobody would lend any money. So what is the statutory position about insolvency? And there are no particular provisions in the Insolvency Act 1986 that deal with TLATA, which came 10 years later. So Section 335A(1) of the Insolvency Act 1986 seems to defeat the provisions of TLATA in 1996. This is what the Insolvency Act said. Any application by a trustee of a bankrupt estate under Section 14 for an order under that section for the sale of land shall be made to the court having jurisdiction in relation to the bankruptcy. So the application of Section 14 is therefore connected with the hearing of the bankruptcy petition. The court's powers are quite limited, and they are as set out in Section 335A.2. On such an application, the court shall make an order such as it thinks just and reasonable, having regard to A, the interest of the bankrupt creditors, B, where the application is made in respective land, which includes a dwelling house, which is or has been the home of a bankrupt or the bankrupt spouse or civil partner, or former spouse or former civil partner. The conduct of the spouse, civil partner, former spouse, and former civil partner, so far as contributing to the bankruptcy. 2. The needs of the financial resource of the spouse, civil partner, former spouse, or former civil partner. 3. The needs of any children. And C. All the circumstances of the case other than the needs of the bankrupt. So that's the end of it. So they'd gone back and later put civil partner in because civil partner didn't exist when 1986 is there. So the Act is still intact with just a few minor addenda. So Harrington and Bennett, 2000, there were 5 features of Section 335A of the Insolvency Act 1986 that came up. So 1, where the application is made over a year after vesting the bankrupt's property in the trustee in bankruptcy, the interests of the creditors are uppermost. Second of all, the court can only disregard the creditor's interests in the most extraordinary situation. And then third of all, the categories of extraordinary situations are not closed. They could be added to. More ones we haven't envisaged thus far could arise. That means the judge could decide, okay, this is an extraordinary situation, we're going to have to make an exception on a ground that we haven't made an exception before. 4, these exceptional circumstances are outside the usual melancholy consequences of debtor and providence. Stop there. It can't be that you're very in debt or you're very foolish, tough, that's life, you hired the money, you've got to live with the consequences. Lastly, the proceeds of sale cannot be used to entirely discharge the trustee in bankruptcy, and that's not considered an unusual situation. So at the time of Harrington, we can see we've gone back to the position that was in citro because the interests of the creditors override those of the householders. So that's enough for the moment.